Well, I was prepared to adjourn this case because it's my understanding that Miss Jackson is in labor. But actually she's here. That was the email that I got from her attorney she was in labor.
Yes.
That's not how it works, but okay.
Today, we have a landlord-tenant hearing in Judge Simpson's court. This is a failure to pay rent case. However, this defendant is in labor and still shows up to court. Let's get into the hearing.
NCDG Realty and Property Management versus Teja Jackson.
Good morning, Your Honor. David Fink here on behalf of the plaintiff.
Good morning, Your Honor. My name is Emily No, and I'm requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Mira Edmonds on behalf of defendant Teja Jackson.
One of these days, I just want to say no, but okay. Permission to practice is granted.
Thank you.
How are you?
Judge Simpson as Teja Jackson. He said my name wrong again.
Okay, we do what we can. When people put their name in, we're not really responsible. We just need to know who's there. So if you put it in, then it'll get spelled correct.
No, you're pronouncing it wrong.
Okay, I do what I can. You're one of 1,000 names for me. I do my best. I apologize.
Okay.
All right. What are we doing on Miss Jackson's case?
Well, I was prepared to adjourn this case because it's my understanding that Miss Jackson is in labor. But actually she's here. That was the email that I got from her attorney she was in labor.
Yes.
That's not how it works, but okay.
Your Honor, if you don't mind if I interrupt, we did send that email to Mr. Fantera yesterday, but we actually spoke with our client this morning. And obviously you see that she is very much in the hospital based off of Zoom. But this case is incredibly important to her, but we are asking for a final settlement conference instead. We are hoping for a settlement in the meantime, but obviously, of course, if that doesn't work out, we'd like a final settlement conference.
Okay, what are my issues here?
Your Honor, if I may, there's a couple issues. One is there are still some outstanding maintenance issues in the apartment, which I guess I'll address now because I got an email, I think on Wednesday, from Ms. Snow or Mr. Kennedy, I forget which, telling me about some maintenance issues. My client reached out to Ms. Kennedy, to Ms. Jackson, and she didn't get back, which is when Ms. Snow said, oh, well, she can't respond because she's in labor. So I guess we need to get in. So is Ms. Jackson going to respond to my client with a date?
Your Honor, I'd like to say that she did receive a voicemail as of yesterday around 9 a.m. That was in the middle of her getting to the emergency room and being checked in. So she was not, of course, able to respond to that call. I mean, she is very much in the process of giving birth. So that's pretty reasonable to not be able to respond right away.
Okay, I get that. I guess the bottom line to the question is authority given for the landlord to enter to do the repairs?
She is on the phone right now, so I'm going to defer that question to her.
So, Your Honor, I do not feel comfortable with them inside of my property. Actually, the day that we left court, they were supposed to do the repairs because I had some animals inside of my property. They did not do it. All they did was put some traps down. I had a couple of talks with them because my kids are highly allergic to mice and peanut butter, and they literally just put peanut butter traps all over and sealed in some really not professional spots.
All right. Here's the thing. I can set the final settlement conference. The problem here is going to be there have been repair issues noted. The landlord is looking for a time to enter. What I'm hearing right here is the tenant's denying permission to enter. That's fine.
No, I'm not.
They could do a 72-hour notice and enter if that's what they want to do. But this period in time, I'm not going to be holding against the landlord in terms of not making repairs. I just want that clear.
Your Honor, in fact, Your Honor, that happened last time where we gave 24 hours. We tried to reach her to come in on 24 hours notice. She said no. We then gave a 72-hour notice and said, fine, we're coming in. And she said, nobody's coming in until the lawyers talk. And I got on the phone with Mr. Kennedy and we arranged to come in. So what we will be doing in this case today is we'll be giving the 72 hours notice, and we will be going in to do the things that are on that list with or without her consent.
Can I say something, Your Honor?
Go ahead, ma'am.
Okay, that's false. The day that they wanted to come out, my kids were sick with the flu. And I did let them know. I just said that I didn't want the maintenance man getting sick because I didn't know what it is. I have 9 kids and I didn't know what they had. And they're very germy. They're touching on stuff. So I said, could you give me until Monday? They did come out Monday, and that's when they put the traps down. So that's false. They said,
All right, ma'am, I'm not,
Okay.
I don't know that I need to deal with all of that.
Okay.
I'm looking at
I
this
just
current
wanted to put it
list.
out there that I did let them in, but they did not do the work.
Okay. Fine. You're gonna give the 72-hour notice. You're gonna enter.
Mhm.
Try to work it through with counsel if you can. And we'll do it that way. You want a final settlement conference, if it's at that stage.
We could do April 21st at 3:30.
You guys,
You want it that quick, Miss Snow, or do you want, I mean, that's just 1 week away. Why don't we give us 2 weeks to get everything done, Your Honor?
I'm sorry, Judge. This is Mira Edmonds. Unfortunately, next Friday, I have a doctor's appointment that was scheduled 6 months ago, and the following Friday, I'm going to be down at a conference. So I think 3 weeks is the earliest that we would be able to do on May 5th.
And I don't have a problem with that because she's actually put her money in escrow for both March and April. And so I think the only other issue that's out there that I think needs to be addressed is the DTE bill. This house was 2 apartments combined into 1. She has the DTE in apartment 1 in her name, but she does not have the DTE for apartment 2 in her name. And I will provide those bills to Ms. Snow, along with a current ledger, which I'm still trying to clean up a little bit by Tuesday. So I think other than that, I think 3 weeks is fine.
Perfect.
hold on a second. What? May 12th. It actually has to be 4 weeks. It'll be May 12th, 2023 at 3:30.
That's fine. And I'll get
And that, if it's a final settlement conference, that's in person.
In person.
Sorry, go ahead, Tia.
Is there a way we can do Zoom?
Ma'am, my final settlement conferences are going to be set in person. So that's where we are. Your counsel's going to be here. Maybe we can work it out. If you can't appear in person, that maybe you can by Zoom, but I'm not guaranteeing that. Right now, I'm ordering it in person.
Okay.
Thank you.
Sorry, to confirm, she has put in April's rent into escrow. Should she put May in there as well?
She should put May's in. She has to pay while this matter is proceeding.
Great. Thank you.
All right. Thank you.
Thank you, Your Honor.
I don't blame the defendant for being upset over the peanut butter traps. She has 9 kids, and they are allergic to peanut butter, so that raises a major safety issue. Traps alone are not safe for kids. I get field mice every once in a while, and I have a toddler. I had to find a safe, humane method to get rid of the mice without having to worry about my daughter getting hurt. Traps aren't safe, and neither is poison around children. The next hearing is May 12th, but it's in person, so I hope I can get an update on this case. Let me know your thoughts in the comments section below. Thank you for watching, and I'll see you in the next video.